How to find out if a trust exists and where to locate it. Do you believe you may have been named as a beneficiary of a trust and are wondering how to find out if it exists? If you suspect a loved one passed away with a trust, it's crucial to take the necessary steps to locate that document. Trusts are inherently private, designed to bypass the public probate process, and are not typically part of any public record, often making them more difficult to find than a will. However, if you believe you were named as a beneficiary or even a trustee, it might be worth your time and effort to go and look for and find and secure a copy of that trust. Here, we're going to walk you through how to find if a trust exists, what to do if a trust appears to be lost, and give you some valuable ideas to help you locate a trust after your loved one's passing. Whether you're trying to locate a trust in California or Texas, this process involves understanding the unique aspects of trusts and why locating a trust can be especially difficult. What is a trust and how does it work after someone's death? A trust is a legal arrangement where one person, known as the trustee, holds the title to an asset and manages it for the benefit of another person or group of people, known as the beneficiaries. After the death of a trust creator, the named successor trustee takes over management of the trust and its assets and distributes the assets to the beneficiaries as dictated by the trust instrument. Are trusts publicly recorded? As you search for trust documents, you might wonder whether they're recorded or filed in some public database. While this is a reasonable question, it's important to understand that trusts are non-public, and they're used to typically bypass the public court system entirely. They are not a matter of public record generally. Unlike wills, which are often filed with the courthouse, required to be, trusts are designed to be private, and they're not generally recorded with a county clerk, courthouse, or other public database. Why are trusts not public records? Trusts generally are not part of the public record because they don't require court involvement to be administered. Only the trustee and the trust document are needed to begin managing the trust and administering it, allowing assets to be distributed to beneficiaries without court oversight. While this privacy is an advantage, it also means that if a trustee fails to provide copies of the trust to beneficiaries, it can be really difficult to access the document, unlike with a will, which again needs to be publicly filed with the court. There are some exceptions where a trust might become part of the public record. For instance, if the trust includes real estate and the deeds transferring the property titles to the trustee, sometimes they're recorded with a copy of the trust with the county clerk. While this doesn't mean the trust itself is always recorded, sometimes it is, and it can confirm the trust, and if nothing else, the trust's existence. Additionally, if the trust has been involved in litigation, such as property disputes or trustee misconduct claims, then too, the trust might become part of that public record. Also, testamentary trusts, which are created through a will, are also public records because that will is administered publicly through the probate court processes. Occasionally, deeds may contain a brief summary of trust terms, and that's most often in a certificate or certification or an abstract of trust. Regardless of what the title of that document is, these documents aren't substitutes for the actual trust agreement itself, and many times might be outdated by a trust amendment or modification or restatement. Again, it can be a good starting point for locating an actual trust agreement. Who might have information about the location of a trust? When searching for a trust, there are several parties that may have information about the document or where it's located. The successor trustee, the person appointed to settle or manage the trust after the person's death or incapacity, often has an access to the document. If the successor trustee doesn't have a copy of the document or access to it, sometimes professionals involved in the creation of that trust, such as an estate planning attorney, a financial advisor, or accountant, may have the information or even a copy of the document. Additionally, close relatives of the decedent, such as a spouse, siblings, or children, might know where the trust is, whether it's in a safe deposit box, or another secure location, or they might even have been given a copy of it. Who has a right to copies of the trust? In California, beneficiaries and heirs of the decedent are entitled to receive copies of the trust from the successor trustee after the settlor dies and the trust becomes irrevocable. They are not entitled to copies of the trust before that. In Texas, trustees must provide beneficiaries with full disclosure of all material facts that might affect the beneficiary's rights. In the real world, this usually means providing a copy of the trust. Unlike California, however, this right may apply before the trust becomes irrevocable and is not automatic. If the trustee fails to provide interested parties with copies of the trust, it's crucial that you work with a trust litigation lawyer to pursue them. Without getting a copy of the trust and examining it, it's difficult to know whether the document's valid, what assets might be in it, what they might be entitled to, etc. In other words, it's going to be really difficult to know what your rights are or how to enforce them. What are the 4 common places trust documents are usually found? To locate trust documents, consider checking with the following people and places. You might uncover valuable insights or even find the documents themselves. Consider contacting the following people and checking in the following places. Number 1, estate planning attorney and accountant. If the successor trustee is unsure how to determine if a trust exists for a decedent, the estate planning attorney that helped the decedent or one of their financial or legal professionals might have the answers. They might have the document. Although there's a chance the decedent may have used software or LegalZoom or something else to create their own trust, it's more likely that those with significant assets worked with an estate planning attorney or a financial planner or CPA, or all of those during their estate planning process. In these cases, those professionals or one of them may know where the trust documents are stored, or they might even have copies. Estate planning attorneys or financial professionals sometimes hold copies or even original trust documents, perhaps in a safe, because they were involved in drafting them and they secure them for the decedent until they're needed. Attorneys and other professionals might have ethical obligations, including confidentiality, that might cause a problem when searching for a trust. In that case, it might be necessary to hire a litigation attorney who can pursue the document formally through subpoena or other means. Number 2, safety deposit boxes or safes. After creating a trust, it's common for the person who created it to store the document in a safe place, like a safety deposit box at a bank or in your personal safe at your home or office. Access to the safety deposit box often depends on who owns the box. Many decedents share their safety deposit boxes with their spouses, who are often joint owners and will have a key or at least access to the box. If the safety deposit box is solely owned by the decedent, access is still possible, but only by the executor or administrator of the estate. Under the California Probate Code, specifically Section 331, you're going to need certified copies of the decedent's death certificate and proof of identity to gain entry. It's advisable to try and find the key to the safety deposit box to avoid paying the bank hundreds of dollars to unlock it for you. If the safety deposit box is in the name of the trust, the decedent may have provided the bank with a copy of the trust when opening the box in the first place. In such cases, the successor trustee might be able to access the box by presenting a certified copy of the settlor's death certificate and proof of identity. Texas offers some different procedures for examining safe deposit boxes. According to Texas Estates Code Section 151.001, a probate judge may order a bank to open the box if the interested party shows the judge that the safe deposit box may contain a will. Texas law also allows banks to open safety deposit boxes for the decedent's spouse, parent, adult descendant, or executor under Texas Estates Code Section 151.003. Gaining access to a decedent's home or office safe can be more challenging unless someone, such as a spouse or child, knows the combination to the safe. If the combination is unknown, they may need to contact a locksmith or a safe cracker to open the safe. Number 3, close relatives or even friends of the decedent. This approach relies on your familiarity with the decedent and their closest allies. Those who were closest to the decedent at the time they passed often are most likely to know where you might find a copy of the missing trust document. For instance, if the decedent lived with someone such as a spouse or partner or even a caregiver, they might know where to look, or they might have been informed about where the trust documents were kept by the decedent. The decedent may also have shared the location of their trust with an adult child or trusted business partner. You want to contact whoever was closest to the decedent to see. Number 4, the decedent's home, office, or storage units. Although most settlers are careful to store their trust documents in a secure location, some leave them in an office filing cabinet, a desk drawer, or even in a storage unit in a box with a bunch of other stuff. The key is to be exhaustive in your search when trying to locate documents. Once you've exhausted all your efforts and still can't find the document, it's possible there may not be a trust, or that they may have destroyed it, or it was simply lost. How do you locate a lost trust? If you're the creator of a lost trust, you may be able to look through your records to find whether you had an estate planning attorney or financial advisor. Perhaps you made a payment to them using a check or received correspondence from them via mail or email. Any of these documents can prove useful in helping you find where you kept your trust documents or securing copies of them. If you've been searching for a decedent's trust but haven't had any luck finding it, then it could be that the decedent simply didn't make one. Someone is hiding it, or the decedent intentionally destroyed the document so that their assets would be disposed through other means, such as a will, perhaps there's a holographic will, or even estate succession. At RMO, we protect people like you every day. Contact us today to see how we might be able to help.